we have to discuss the privileges, parliamentary privileges, and the significance of the parliamentary privileges and how do they impact the functioning of the parliament. Now, the significance of the parliamentary privileges and how do they impact, right? Parliamentary privileges are nothing but the special rights and immunity. So privileges usually mean that there are special rights and also immunities. So privileges means we say that there are rights as well as the immunities. Okay. These are the terms which are used for the privileges enjoyed by the members of the parliament and the state legislature, ensuring they can perform their duties effectively without undue interference. There is no interference. So we can say that there is no interference. Now we have to go for the significance of parliamentary privileges. First, there is freedom of speech. Freedom of the parliamentary privileges are mentioned in Article 105 of the Constitution. So Article 105 of the Constitution deals with the parliamentary privileges, the privileges which are associated with the parliament, right? So parliamentary privileges are mentioned in Article 105 of the Constitution. We have first is the freedom of the speech. The members can speak freely in the House without a fear of legal repercussions, promoting the open and robust debates. So we have Article 105 is for the parliamentary privileges. Article 105 is for, we have it for the parliamentary. So we have it for the parliamentary privileges. Right. The protection from the legal actions. The members are protected from the legal action for anything said or done within the House, ensuring the independence of the House. Right? Independence within the House, they have to speak. Within the House, they have independence to speak. Now we have right to information. Members have the right to seek information. From whom they can seek information? They can seek information from the executive. So members have the right to seek information from the executive, facilitating accountability and transparency. So they seek information from the executive to facilitate the accountability and transparency. Exclusion of interference. The judiciary and executive cannot interfere in the proceedings of the parliaments, even the judiciary as well as the executive, to maintain its autonomy. Now we have that there is exclusion from interference. We have like exclusion from the interference, right? And then we have disciplinary powers. The House can regulate its own proceedings, the power to regulate its own proceedings and discipline the members for unduly behavior, maintaining order and decorum. This is for unduly behavior. To maintain the decorum of the House, they can use disciplinary powers. So the first is freedom of speech. Privileges are mentioned in Article 105, and then we have freedom of speech. Next, we are having the protection. We need to protection from legal action. There cannot be a legal action taken for speeches given within the parliament, within the houses, right? Right to information with respect to the executive. They have the right to information with respect to the executive. Exclusion of the interference. The judiciary and the executive cannot interfere in the proceedings of the parliament, maintaining its autonomy. So we say exclusion of the interference means the judiciary and even the executive cannot interfere. We have both the judiciary and then we have the executive. They both cannot interfere in the proceedings of the parliament, maintaining its autonomy. Right. Now they also have the disciplinary powers. The House can regulate its own proceedings. It is regulating its own proceedings and discipline members for unruly behavior. It can discipline the members for the unruly behavior. It should maintain the order and the decorum. Now, the factors impacting on the functioning of the parliament is this ensures independence. The privileges protect the independence and integrity of the legislative processes. So, this is ensuring the independence. Right. Promotes free debate. Members can debate and discuss issues freely. So the issues are discussed freely. It leads to comprehensive policy making. Facilitates accountability by enabling the members to seek information. and question the executive. Privileges ensure government accountability. So we have accountability. Maintains order. The disciplinary powers helps in maintaining the order and the decorum within the house. Now what are the relevant articles? We have Article 105 and Article 194. Article 105. And then we have Article 194. Article 105 is respect to the powers, privileges and immunities of the Parliament and its members. So we have powers and we also have the privileges. Then there is also immunity. Powers, privileges and immunity of the Parliament. So powers, privileges and immunity of the Parliament and its members as well. Now, Article 194 is the powers, privileges, and immunities of the state legislatures and their members. T.H. Kiran Jain versus N. Sanjeeva Reddy, 1970. Supreme Court upheld the immunity of the members of Parliament from legal action for statements made in the House. Quixoto Holohan versus the Zilu, the Supreme Court discussed the role of parliamentary privileges in the context of anti-defection law. So Quixoto Holohan versus the Zilu is related to anti-defection. Now we have the conclusion. Parliamentary privileges are essential for the effective functioning of the legislative bodies, ensuring their independence, promoting free debate, and facilitating accountability. They uphold the democratic principles by enabling members to perform their duties without fear or favor. Discuss the significance of parliamentary privileges. How do they impact the functioning of the parliament? Parliamentary privileges are special rights, immunities, and exemptions they, which are enjoyed by the members of the parliament and its committees. These privileges are crucial for the effective functioning of the parliament, ensuring that members can perform their duties without undue interference. They are outlined in the Indian Constitution and have been interpreted through various Supreme Court judgments. Parliamentary privileges, judgments, and amendments. We have Article 105. Provides the framework for the privileges of the Parliament. It states that the members of the Parliament have the freedom of the speech within the House and immunity. The same is 194. So, articles which are important are Article 105 is related to the parliamentary privilege, right? So, Article 105 is related to the parliamentary privilege of the uh, it is a parliamentary privilege, that's all. And Article 194. If you add 89, you get like 194. It is related to the privileges of the state legislatures. So this is related to the privileges of the state legislatures. We have seen two articles, right? Article 105 and Article 194. And the significance of the parliamentary privileges are freedom of speech, first one. The members can speak freely without the fear of legal consequences, ensuring that robust debates and discussions are taking place. This is crucial for the legislative processes and democracy. Article 105. Immunity from legal action protects the members from being prosecuted for actions or the statements which are made within the parliament, fostering the independence in legislative actions. Article 105 2. Right to regulate internal affairs. The Parliament has the authority to manage its own affairs without outside interference. Ensuring the smooth functioning and autonomy is Article 118. Regulation of its own internal affairs is Article 118. Supreme Court's Keshav Singh case addressed the extent of parliamentary privileges and the judiciary's role in reviewing the actions taken by the parliament under these privileges. P.V. Narasimha Rao case, 1998. It affirmed that the members of the parliament enjoy immunity from legal proceedings for their speech or vote within the parliament. Now we have constitutional amendments and legislative changes. 44th Constitutional Amendment Act of 1978. So we have the 44th Constitutional Amendment Act, which is of the 1978, right? Although it primarily dealt with the emergency provisions, it also reinforced the importance of the civil liberties which indirectly impact the parliamentary privileges. So, how does this 44th Constitutional Amendment Act is related to privileges? This primarily dealt with the emergency provisions. It reinforced the importance of the liberties, which indirectly impacts the parliamentary privileges. Anti-defection law is in the 52nd Constitutional Amendment Act of 1985 and 91st Constitutional Amendment Act of 2003. We have two constitutional amendments for the anti-defection law. The first one is the 52nd Constitutional Amendment Act of 1985 and the second one is the 91st Constitutional Amendment Act of 2003. This law, while aimed at curbing the political defections, also impacts the parliamentary privileges by specifying conditions under which members can lose their seat. Impact on the functioning of the parliament: it ensures free debate, robust discussions. Members can discuss and debate issues freely, contributing to effective lawmaking. The privilege of free speech ensures diverse viewpoints are considered, protection from the external pressure. Independence of the members: the immunity from external legal proceedings allows the members to perform their duties without fear, maintaining the independence and integrity of the legislative processes. Autonomy in the internal matters. Self-regulation: the Parliament's power to regulate its own proceedings without external interference helps maintain order and discipline within the House. Now, regulation of its own is Article 118. Right, regulation of its own internal matters is Article 118 of the Constitution. This is of the Parliament. Challenges and misuse, right? There is potential for the misuse. While privileges are meant to protect, they can be misused by the members to evade accountability. This can lead to calls for clearer definitions and limitations. Judicial review: the judiciary has played a crucial role in balancing these privileges within the rule of law, ensuring that they are not misused to obstruct the justice. We say that the parliamentary privileges are fundamental to the functioning of democratic legislature. They ensure the members can perform their duties without undue interference, contributing to effective governance. However, it is essential to balance these privileges with accountability to prevent misuse. The judiciary's role in interpreting these privileges ensure that they are exercised within the bounds of the Constitution, maintaining the integrity of the parliament and the democratic processes. By protecting the independence of the legislature and fostering open debate, parliamentary privileges play a crucial role on the functioning of the India's democracy. Now we have to know the critically analyze the provisions of the 10th schedule of the Indian Constitution. How does it has an effect? How effective has anti-defection law has been in curbing the defections? 10th schedule is properly known as the anti-defection law. So we have the 10th schedule, and the 10th schedule is known as the anti-defection law. So we'll be having the 10th schedule. The 10th schedule is known as the anti-defection law. Right. It was added to the Constitution by the 52nd Constitutional Amendment Act of 1985. It aims to combat the frequent political defections by the legislatures. So we have the political defections is by the legislators, which undermine the stability and integrity of the elected governments. Provisions for the 10th schedule is disqualification grounds. If a member voluntarily gives the membership of the party, so we have a member and the member has voluntarily gave the provisions, right? Disqualifications on the ground, and we have certain exemptions. Decision authority: if you voluntarily give up the member of their party, you are disqualified. A person belongs to a particular political party and he enters into the parliament as a member of that political party. Now he voluntarily gives up. He voluntarily gives up the membership of the party. So he voluntarily gives up the membership of the party. This can lead to disqualification. He voluntarily gives up the membership of the party. This can lead to disqualification. If a member votes or abstains from voting contrary to the party's directives without prior permission, right? If he is voting against the party or if he is not voting, is what we call it as abstaining against the party's directives. We have the parties has given certain directives. Now this without the prior permission, this attracts um, defection. For independent members, if they are joining a political party, this is after the election. So, independent members are not allowed to join the political party. We have independent members, right? So, the independent members are not allowed to join they are not allowed to join the political parties after the elections. For the nominated members, if they join the political parties after 6 months from their nomination. So we have the nominated members. If the nominated members join the political party after 6 months from their nomination. Exemptions is in case of merger, at least two-thirds of the members of the party agree to merge with another party, they are not disqualified. Speaker, Deputy Speaker, Chairman, and Deputy Chairman are allowed to resign. They are allowed to resign. So the Speaker, Deputy Speaker, Chairman, Deputy Chairman are allowed to resign without facing disqualification. Now we have the merger. If there is a merger of at least two-thirds members of the party. So the merger of at least two-thirds. Merger is two-thirds, right? To allow the merger, if there is a merger and two-thirds of the members agree to merge with another party, there are no disqualifications. Decision authority is the presiding officer and it is subjected to judicial review. Political stability is being maintained, has reduced the frequency of opportunistic floor crossing, contributing to the stability of the government. Party has discipline, ensures the members adhere to the party policies promoting coherent governance. Merger provisions allows for party mergers accommodating political realignments without destabilizing the legislature. The weakness are delay in the decision making. The presiding officers they delay in the decision making, sometimes aligning with the party interest. Judicial review. The decisions of presiding officers are subject to judicial review, but the courts are slow, allowing the defectors to complete their terms. Voluntary giving up of the membership. This phrase is vague and has led to various interpretations, complicating the enforcement. Kyoto Holohan is like the validity of the 10th schedule is subject to judicial review. So Kyoto Holohan versus Ajilu, this case is in 1992 and this case is related to the speaker makes a decision, right, or the presiding officer. This decision is subject to judicial review. Right. The validity of the 10th schedule, it has upheld the validity of the 10th schedule. So Kyoto Holohan versus Ajilsu has upheld the validity of the 10th schedule, but it has allowed for the judicial review of the presiding officer's decisions. Ravi S. Nayak versus Union of India 1994, it clarified that voluntary giving up of membership is not synonymous with rejection and can be inferred from the members' conduct. Manipur Legislative Assembly 2020, the Supreme Court ruled that disqualification petitions should be decided within a reasonable period. So we have Manipur Legislative Assembly. This is a recent case, right? Here the Supreme Court ruled that the disqualification petitions should be decided within a reasonable period. Ideally, this must be within 3 months. So the Supreme Court suggesting a time framework for the disqualification, right? Mm. Now, what is the conclusion? Well, the 10th schedule has played a significant role in curbing the political defections and ensuring political stability. Its effectiveness is hampered by delays and ambiguities in its implementation. The need for impartial and timely decision making by presiding officers is crucial for the anti defection law to serve its intended purpose fully. The role of the Speaker in implementation of the anti-defection law. What are the challenges faced in ensuring the impartiality? The Speaker of the Legislative Assembly is playing an important role in implementing the anti-defection laws as per the 10th schedule of the Indian Constitution. The Speaker's decisions on disqualification of the members are crucial in maintaining the integrity of the legislative processes. The role of the Speaker in the decision making. The Speaker decides on the petitions regarding disqualifications of the members under the 10th schedule. The Speaker is allowed to follow fair and transparent procedure of giving both accuser and accused an opportunity to present their cases. and there is also no timelessness. So the decision authority is with respect to the speaker, right? So the speaker is the one who decides. The speaker is the one who decides on the petitions regarding the disqualification of the members under the 10th schedule. So the decision making authority is with respect to the speaker. The speaker decides on the petitions regarding the disqualification of the members under the 10th schedule. Now the procedure is he is giving a fair and transparent procedure. Right, there is a fair and transparent procedure which is ensured by the speaker. Fair and transparent procedure is ensured by the speaker. So we say it is ensured by the speaker, giving both the accuser and the accused is having an opportunity to present their case. Timelessness. The speaker is expected to make decisions within a reasonable time frame to ensure the smooth functioning of the legislature. What are the challenges in ensuring the impartiality? Political bias. A speaker is often a member of the political party, a member of any particular political party. There is a potential for decisions to be influenced by the party politics. We have to write there is a political bias. Since we say that the speaker is a member of a political party, he is a member of a political party. So we say that the speaker is a member of a political party. There is a potential for the decisions to be influenced by the party politics. Pressures from the parties. The speakers may face pressures from their own parties to delay or expedite decisions based on political convenience. Own parties pressure to delay, lack of clear timelines. The absence of mandated timelines for the decisions allows for delays that can be exploited for political gains. Judicial intervention is while the speaker's decisions are subject to judicial review, the intervention is also slow, allowing biased decisions to impact the legislative processes. Now we have certain Supreme Court cases, right? Quixote Holohan versus the Zilu in 1992. We had this case. It upholds the speaker as having the authority for disqualification, and the Supreme Court emphasized the need for fairness and transparency in decision making. And the speaker's verdict is subject to the speaker's anti-defection verdict is subject to the judicial review. Navam Rebia versus the Deputy Speaker 2016. The Supreme Court ruled that the Speaker cannot disqualify the members while a motion for their own removal is pending, highlighting the potential for conflict of interest. Speaker, he cannot disqualify a member. While there is a motion for the removal of the speaker in itself, this is impartial, right? This case is in 2016, Nabam Rebiya versus the Deputy Speaker. Now, Manipur Legislative Assembly is where the time framework. The Supreme Court emphasized the need for the speakers to decide on disqualification matters within a reasonable period, ideally within 3 months. Constitutional amendments is the 91st Constitutional Amendment Act of 2003 strengthened the anti-defection law by making it applicable even in cases where parties split, requiring two-thirds of the members for a legitimate split. So for the split, you need to have two-thirds of the members for the split and restricting the size of the Council of the Ministers. The role of the Speaker in implementing anti-defection laws is critical but fraught with challenges. Ensuring impartiality requires adherence to the principles of natural justice and timely decision making. Strengthening institutional mechanisms and judicial oversight can help mitigate the biases and enhance the effectiveness and anti-defection law. How does the anti-defection law impact the stability of the government? Provide with examples. Anti-defection law is enacted through the 52nd Constitutional Amendment Act 1985 aims to prevent the political defections and ensure stability in the government by disqualifying members who defect from their parties. Now, what does the anti-defection law does? The anti-defection law is brought into by the 52nd Constitutional Amendment Act of 1985, right? This aims to prevent, first it is preventing the political defections. It prevents the political defections and it also ensures stability. So this also ensures the stability. Stability in the government. So stability is being ensured by disqualifying. So it is first disqualifying members. Members are disqualified when they defect from their political parties. Reduction in the political defections. By disqualifying defectors, the law discourages opportunistic shifts in loyalty, thereby promoting political stability is being promoted, right? And party is having certain discipline. Members are less likely to defy the party directives, ensuring cohesive party behavior and stable government. Government stability. Preventing mass defections help in maintaining the stability of the government, especially in the coalition setup. Now, it also curbs the corruption. By reducing the practice of this is called as horse trading is by money they are purchasing, right? Horse trading. The law helps in curbing the corruption with anti-defection, right? Now, in 1985, we had the cases, 1985 to 1993 is the initial phase. The law was effective in reducing defections, promoting stability, and as seen in various states. In 2004, Maharashtra, the law was invoked when a group of MLAs was defected from the Congress party, leading to their defection. Now, in 2019, Karnataka, there's disqualification of 17 MLAs. We had a disqualification of the 17 MLAs who defected from the Congress and the JDs to BJP underscored the law's role in preventing destabilization. 10th schedule, Article 102 and 191 is disqualification on the grounds of defection. So we have Article 102 2 and Article add 191 2. So articles, we have two articles right over here. So article 102 and article 191 2. These are related to disqualification on the grounds of defection. So these two articles are very important. Article 102 and then we have article 191 2 on the grounds of defection. Right. Now, Kyoto Holohan versus the Gilu in 1992, the Supreme Court upheld the constitutionality of the anti-defection law, emphasizing its role in ensuring the political stability. The anti-defection law has played a crucial role in promoting the political stability and curbing the opportunistic defections. While it has been effective in maintaining the government stability, its implementations and interpretations continue to evolve. Now, here is a question. Pre-poll alliances, right? Some parties they join together during pre-poll. There are different parties. The parties they join together during pre-poll and they make an alliance. For example, India alliance, and then we have NDA alliance, right? So, do we need to follow anti-defection law for those alliance as well? Pre-poll alliances are agreements between political parties to contest elections together. The current anti-defection law does not explicitly cover the pre-poll alliances, leading to debates on whether it should be amended to include them. So, what is the pre-poll alliance? Is nothing but the agreement. It is an agreement between political parties. But anti-defection deals within political parties, right? So, this is an agreement between the political parties. It ensures clarity and consistency. Including the pre-poll alliances would provide a clarity and ensure consistent application of the law. Right. Prevent opportunism. Opportunism. It would prevent members from shifting allegiance post-election, respecting the mandate given by the voters. Strengthen the coalition politics. It would solidify the pre-poll alliances, promoting stable coalition governments. Arguments against are complexity in implementation. Defining and regulating the pre-poll alliances could be complex and lead to legal challenges. Infringement of the autonomy. Parties may view it as an infringement on the autonomy to make post election strategic decisions. Flexibility in the politics is being hampered, and implications again you have political stability, electoral integrity, and then the legal challenges. Amendment could face legal challenges impacting its implementation. With respect to anti-defection, we have 10th schedule, Article 102.2 and Article 191.2. Then judicial interpretations, Quixote Holohan versus Achilu. Like amending the anti-defection law to include three-pole alliances could promote political stability and uphold integrity. However, it requires careful consideration of potential complexities and legal challenges. Now, examine the judicial interpretations of anti-defection law. Quixote Holohan versus Achilu. Ravi S. Nayak vs. State Union of India, Rajendra Singh Rana vs. Swami Prasad Mayura, Manoj Narula vs. Union of India. This one case alone is enough over here. And it is the Supreme Court upheld the constitutionality of the anti-defection law and the role of the speaker in disqualification. However, it has allowed judicial review of the speaker decisions, ensuring the check on potential misuse. Right. I think this one case is enough. It strengthens the party discipline. Judicial interpretations have reinforced the need for party discipline, reducing the instances of defections. Enhanced accountability. By allowing judicial review, this judiciary has ensured accountability in implementation of the law. Clarity in application. Clarifications provided by the judiciary have brought greater clarity and consistency in the application of the anti-defection law. Check on the speaker's power. The judicial's oversight of the speaker's decision has acted as a check on the potential misuse of the power. 10th schedule. Judicial interpretations have significantly shaped the understanding and application of these provisions. Quixote Holohan vs. Sachilhu, 1992. It is a landmark judgment on constitutionality of the anti-defection law. We can also include one case to 1994. Ravi S. Naik vs. Union of India, 1994. The concept of voluntarily giving up the membership. Now, judicial interpretations have played a pivotal role in shaping the anti-defection law, ensuring fair and consistent application. They have strengthened the party discipline, enhancing accountability and providing clarity, thereby influencing the function of the political parties and stability of government in India.